This is the House Judiciary Committee non-civil. Good afternoon to everybody. Let me ask, if you would, if you'd please put your phones, BlackBerries, whatever, into the silent or vibrate position. I'd really appreciate it. The members would. I know the fellow audience members would as well. We've got 3 bills on the agenda. We're going to go ahead and start off with House Bill 199 by Representative Jurgensen. Representative Jurgensen, welcome. And if you would, just pull one of the mics toward you. And if you've got a guest, if you'd like to introduce your guest, we certainly would welcome him.
I certainly will, and I want to thank you for having this hearing today, and thank you, committee, for being here. I'd like to introduce Judge Townsend, who is the on the executive committee for the magistrate court judges and for Whitfield County. That's correct. And he will be providing some testimony to the committee today as well.
So, Judge, your part of your charge is to go ahead and organize the different judges within your magistrate judge clan and get them into a straight line.
Absolutely.
How do you find that?
Like herding cats.
Stark similarities. Stark similarities. Representative Jurgensen.
Thank you, Mr. Chairman. Committee, bring before you House Bill 199 this morning. It passed out of subcommittee last week unanimously. And I would certainly like to thank the Judges Council for providing testimony last week as well. This bill was brought to me by my magistrate court judge through an issue that he found in the code, and we're trying to clean it up a little bit. And basically, I'll just give you a quick overview and then allow Judge Townsend to testify as well. Currently, citizens may petition a magistrate court for an arrest warrant to be issued against another person for violations, and currently the code requires that a hearing be held for such a petition. What this bill would do is simply state that it gives the magistrate judge some discretion, and that he may deny a hearing without notice if the application for the warrant does not demonstrate sufficient basis for issuing the warrant. That's simply what it does. It's pretty cut and dry, and I'd like to have Judge Townsend elaborate on any points that he feels necessary.
Good afternoon, Mr. Chairman, members of the committee. Thank you. It's an honor to be here today to testify. This, as Representative Jurgensen said, this is a very simple bill. It just simply clarifies the language of 17440, so that there are always cases in a months or years' time in magistrate court where people come in and their case is either very frivolous. It's sometimes, as it used to be in magistrate court, the first person that got to the court got the warrant. Since we've started doing these pre-warrant hearings, as we call them, it's really cut back a lot on that, which is good for everybody concerned. That way we're sure that we hear both sides of the story. You get a lot more clarity to the whole story that comes up. But a lot of times people try to use these things as revenge against somebody else for taking out a warrant on them. And there's a lot of frivolity. Sometimes they'll come in and they will lose their case on a pre-warrant hearing, and then they'll try to come back a month later and try it again. So this would keep us from having to hear those things again. And if they have no basis for it, and sometimes people can come in now and ask for a hearing that really have no standing to the pre-warrant. They're just somebody, that doesn't like somebody else, and so this again would give us the ability to deny those hearings or to dismiss those hearings without having to jump through a lot of hoops and go to the great expense of subpoenaing people and bringing them into court for the hearing. And so our position is that this is just simply a clarification of our ability to dismiss a warrant, and it would be something that somebody without something without merit couldn't come to the court.
A lot of times we try to find, the law of unintended consequences around here. What's the try, if you can, to give us the worst case scenario of how this could possibly backfire?
Well, the worst case scenario on how it could backfire is if you dismissed something that was actually valid, which would be hard to do because they have to fill out an application when they come in and explain in 100 words or less. Most of the time we do get some that are written on 3 or 4 sheets of paper as to what they try the case on the paper instead of in the hearing. And that would be a very, very rare occurrence because when they explain on there, you can tell right off the bat if it's civil instead of a criminal action. You would just dismiss that, and we tell them, perhaps you might want to go the civil route here instead of criminal. I really can't see anything bad happening from the denial, but of course, like I say, if you denied something and it turned out at some point in the future, there to be more to it than what they had written on that application, then that could be one of the unintended consequences. But I wouldn't. We've been doing this in Whitfield County for 2 years before this came out, so about 10, 11 years, and we've really never had a problem other than what I alluded to at the beginning.
Okay. Judge Abrams.
Promotion.
Representative Abrams.
That's really accidental, but thank you for the promotion.
It is my pleasure. Oh, you'd wait. Okay.
Mr. Chairman, I might make one other
Yes, sir.
point, and there are other areas or other paths of recourse.
Sure.
Should this happen, should a valid claim be denied. It's my understanding that there still is the law enforcement route that can be taken if somebody feels like it was denied in error. The DA route is still an option, and certainly not an attorney nor pretend to be one, and I don't know the Latin term, but I know that they can go to Superior Court.
Mandamus.
Mandamus, that's right. So there's 3 other routes of potential areas that a victim of this sort could go.
Okay.
So.
And this has the support of the Council of Magistrate Court Judges, correct?
Yes, it does.
Okay. Ms. Abdul Salam.
Thank you, Mr. Chairman. Just to clarify, this does not include TPOs and TROs and things like that.
No, ma'am.
It's just by coincidence there was a case in the news last night where a judge refused to hold a hearing, and the young woman was shot 9 times. This would not have anything to do with those kinds of issues.
No, ma'am.
Thank you.
Thank you. That's all I see for the author, the judge. Thank you so much.
Okay, thank you.
Mr. Franklin?
At the proper time, I'd like to propose an amendment.
Thank you for the notice on that. We do have, I think, 1 or 2, actually just one other. Tanya Griesbach with the Judicial Council. Would you like to be heard on? Oh, I'm sorry. Representative Littis does have a question of the author or the judge.
And I don't mean to anticipate too much what Representative Franklin's getting, but as long as the judge is up here, wanted to ask them. I mean, the wording in the statute currently is sufficient basis. Would there be any objection from the magistrate courts to substituting probable cause for sufficient basis? As I understand that, that's the standard that you have to have anyway. And it just might be a little bit the concern that was raised, and again, Representative Franklin can stop me if I'm stealing any thunder, was that if you get home cooked, that's no disparagement, of course, any individual judge or the judges in general, but if you do get home cooked, somebody happens to know somebody well, and they can get the case dismissed for reasons other than that. Sufficient basis is a fairly nebulous term, and I just wonder what the reaction would be to substituting, and this was Representative Franklin's idea, not mine, the words probable cause for sufficient basis.
We have had discussions, not necessarily on the probable cause basis, but we did consult with one of our former magistrate judges, who is now a state court judge, Judge Wayne Purdom. He's
The guy that killed my magistrate bill the other day, that Wayne Purdom? Okay, I'm just curious. I'm just curious if that's the same one.
But a very, let's see, how can I work my way on this? A very learned and scholarly judge who edits our bench book, and he's the one that suggested. the language.
That is correct. Yes.
Okay, so he's the one that suggested the language of the bill. So I really can't speak to how they would feel about it because this is the language that we had discussed and had, come to an agreement on.
And let me tell you, I think it's a good bill, and I've done magistrate court work, and I know exactly what you're talking about, and that's a good problem. But I do think that Representative Franklin may raise a very good concern, and it's something I think that's worthy of consideration. I know it's hard to do this on the fly like that, but it's certainly something I think before that we ought to consider probably during the hearing, and maybe somebody can make a quick call to Judge Purda.
Thank you. Ms. Griesbach, did you have a comment?
Sure. I just wanted to say that this is HB 199 is a judicial council supported bill as well, so all judicial council supports it.
Thank you. Thank you for that information. All right. That's all the witnesses I see signed up for House Bill 199. With that in mind, what is the pleasure of the committee? Ms. Randall moves do pass, seconded by Mr. Collins and Mr. Ramsey. Are there any amendments? Mr. Franklin.
Thank you, Mr. Chairman. On line 22, I would propose striking the last three words, a sufficient basis, and replacing with the words probable cause.
Mr. Franklin proposes an amendment on line 22, striking a sufficient basis and substituting the words probable cause. Can we get a response from the author on his feelings regarding the amendment?
Mr. Chairman, I don't necessarily support or do not support, support or not support the amendment. This language was very carefully crafted with the council. Obviously, by the bill number, it was dropped early last session and worked through all last year and over the summer. So I might be hesitant in one way of amending the bill simply because of that reason, but I defer to your judgment and whatever you think.
All right, we like to get feedback from from the interested party, obviously from the author who's spent the most time on it. We'll go ahead and have our vote certainly, but we do value the feedback on that since you've been part of that process and we have not. The question occurs on the Franklin Amendment. All in favor of the general? Any further discussion on the Franklin Amendment? Seeing none.
I would actually like to hear from the judge if there's a difference between probable cause and sufficient basis.
Judge, do you want to address that? I don't know if you touched on that earlier, but
Well, there's sufficient basis is a little more lenient than probable cause. And like Representative Jurgensen said, we've worked on this bill and the language quite a while, and I guess I would like to see it pass as it is, since we have worked on it for a long time, and not having the luxury right at the last moment of looking at a rewording. Like I say, it is a little more lenient than probable cause is, and probable cause is pretty lenient in and of itself. The scales just have to tip a little bit to give you probable cause. So it's basically, I don't want to say it's the same thing because it's not, but it's very close to the same thing.
thank you. Mr. Levitas, we'll go ahead and take that comment and then we'll vote on the amendment.
Yeah, and I just want to say that I am going to vote in favor of the Franklin Amendment, but I want to notify the author of the bill that I fully support what you were doing. I commend you for it. I hope you don't take offense as my roommate to this, but I do think Representative Franklin raises a good point. Sufficient basis to me, if it's not the same standard as the judge points out, it's already a pretty mild standard. I think we need to make sure that we're very clear on what this means. So I'm going to be supporting Representative Franklin on this.
On the Franklin Amendment, which is on line 22, striking the words a sufficient basis and substituting the words probable cause. On the Franklin Amendment, all in favor signify by raising your hand. All opposed? And the amendment is adopted. The question occurs on the motion of due pass by substitute of HB 199. I'm sorry, are there any further amendments? Seeing none, the question occurs on the gentleman's motion of due pass by substitute House Bill 199. All in favor signify by raising your hand. Opposed? And the motion is adopted. Thank you, Representative Jurgensen. Thank you, Judge. The gentlelady's motion. That's correct. Thank you very much. Thank you for straightening me out on that. I apologize, Representative Randall.
Calling him out is really the appropriate term. I think calling
I have here that Judge Tripp Self of the Macon Circuit is the judge of the week. I see Judge Ray in his normal safety position in the back row, but is Judge Self here from the Macon Circuit? He is not. Oh, he had court today. Okay, thank you. We welcome him whenever his schedule allows. Let's call House Bill 1002. Representative Willard has had some issues today that he's had to deal with, so Representative Ramsey, the subcommittee chair from whence 1002 came, has graciously agreed to carry that bill for Chairman Willard. So let me go ahead and open it up for Representative Ramsey just to go ahead and give a report and to present the bill however he feels, however he wants to go ahead and go about that. Please do.
Okay. This is the bill is HB 1002. We're working off a substitute. The subcommittee offered a substitute of the bill, which was in the nature of a friendly substitute. The author agreed to the changes that we offered. The thrust of the bill is to provide for enhanced protection for officers of the court in the conduct of their duty. There are a variety of classes of individuals that are provided enhanced protection in the conduct of their duty. Correctional officers, police officers that provide for enhanced floors in terms of sentencing ranges for aggravated assault. What this bill does very simply is adds officers of the court, which includes judges, attorneys, clerks of court, deputy clerks of court, court reporters, or probation officers, to that protection. And I'll point out a couple of changes from the original bill to this bill. The original bill provided for a floor of 10 and a max of 20 years. We in the substitute, we lowered that floor down from 10 to 5 to get it in line and make it consistent with correctional officers, the enhanced protections provided correction officers. The original bill, there is a distinction in the penalty ranges available for terroristic threats or acts against individuals that are serving or participating in a judicial process. The original bill eliminated the distinction in terms of penalty ranges between a threat and an act. I think it was the sense of the majority of the subcommittee that we don't want to blur that distinction. We still think an act merits greater punishment ranges than a threat. So that's the crux of the bill. Right now the current penalty range is from 1 to 20. This would just move the floor up to 5 if an aggravated assault is committed against one of those enumerated individuals in the conduct of their duty. One of the I guess the most often stated concerns in the two hearings we had on this by a couple of the dissenters on the subcommittee was that we just simply don't believe that we should elevate the protection of one individual over another, and I'll again kind of articulate my response to that now in anticipation of that question coming up. This is not about saying that a judge in a superior court or a clerk acting in a superior court or in any court setting is inherently more valuable or has inherently more worth as a person than anybody else that has an assault committed against them. It's not about that. It's about protecting our institutions. And I used an analogy in subcommittee. I think it's apt. My wife often makes fun of me because I rely too often on sports metaphors and examples to communicate. I'm going to use one here. It is very much like every single professional sport. If you strike a fellow player in the conduct of of that sport, you're going to be subject to probably a suspension of some sort, a penalty. If you strike an official in the conduct of that sport, you're going to be subject to a lifetime ban from that sport, minimum. And it's not because the people that govern these professional sports believe that the official has more value as a human being than their fellow player than a player, but it's because they recognize that these are the guardians of the entire framework of that institution. Without that framework, the institution will crumble. So I think that's the philosophical push behind it. It's not about protecting one person over another. It's about ensuring that Georgians have a safe place to go and get justice, whether it's in a civil or a criminal setting. And with that, I'm happy to answer any questions, Mr. Chairman.
Questions, Mr. Ramsey, Ms. Abrams.
Thank you. Mr. Ramsey, can you look at page 2, line 58? I consulted with Ms. Travis. I'm not certain, but this basically says that you can, as it's currently written, lines 57 and 58, say that you can be imprisoned for not less than 1 year, but also a fine of not less than $100,000. Do you know if that was typographical, if that was not to exceed $100,000?
That section was not altered in the course of the subcommittee hearing. I wish Chairman Willard was here to answer that, to speak to the intention behind those two lines.
Okay.
Ms. Travis, can you speak to, you're, as the drafter, was that a purposeful, or are we looking at, or was that supposed to be 10,000?
Well, no, I think
or not?
Supposed to say not to exceed $100,000 instead of not less than $100,000.
Because I just did a quick search. There's nowhere else in our code where we have a minimum fine of $100,000 for any crime.
That's my impression as well.
Tough budget here. Well, if Ms. Travis believes it was an error, I would take the liberty of on behalf of Chairman Willard saying we would accept it as a although I don't know that I'm authorized to do that, we certainly would accept that in the nature of a friendly amendment.
Members have the ability to amend at will in this committee. So if they got the votes, they've got the amendment. So
at the appropriate
we'll
time,
take that at the appropriate time. Yes, ma'am.
Thank you.
Further questions for the subcommittee chair? Seeing none, thank you for the report, Chairman Ramsey. Judge Ray for the Council of Superior Court Judges. Judge Ray is from Gwinnett County, for those who don't know.
Good afternoon, Mr. Chairman and members of the committee. I'm always glad to be here. The idea for this bill came out of our Security Committee on the Council of Superior Court Judges, and of course it's not limited just to the Superior Court Judges. It would be any judicial officer acting anywhere in the state, including municipal courts and magistrates and state courts as well, and all others. There are other types of courts as well. And I was not at the subcommittee meeting and didn't really hear the debate about that. But I will say this, and I harken back to what was probably the most defining moment that we have had in the judiciary ever, certainly since I've been a judge, which was the death and murder of our judge here in Fulton County, and a death of a court reporter, and as well as the murder of a sheriff's deputy in the course of their official duties. It just so happened that the very next week, that happened on a Friday, I remember, because I was in a drug court meeting and got a text message about what was going on. And that very next week I was trying a jury case and a criminal case. And I was very concerned whether I would be able to get a jury, because everybody was so scared on what had happened. If you remember, Brian Nichols was arrested in Gwinnett County up near the mall of Gwinnett County Mall, or Mall of Gwinnett. Gwinnett Place Mall. All right, we got Mall of Georgia, and I get them confused. And so it was a lot of attention on that. Maybe a little bit more so in Gwinnett than a lot of places. Certainly not as much as in Fulton County, but it was everywhere. It was on CNN constantly. And the jurors who came into our courtroom that day had a look of horror on their face when I told them that we were going to try a criminal case. Now, I quickly explained to them something that I couldn't explain in most cases, which is the defendant was not in custody, so they didn't need to be concerned about him. The charge was relatively minor. You can't imagine the release of energy that statement to the jurors caused when I was telling these prospective jurors that they didn't have to worry about this guy. Now, this case really doesn't impact jurors, and jurors already have special protection under the law. But I bring up the incident to just emphasize what Representative Ramsey has said, that what happened that day in Atlanta reverberated around our state because it was an attack on the judicial system. And we are facing these types of threats, particularly in Superior Court, but really in all courts. But we're getting them from ordinary criminals that we run against. But we have a large number of Mexican cartel drug traffickers that we are trying in the metro Atlanta area. Gwinnett County is thought to be a hub of that type of action because of I-85 and the fact that these traffickers can hide within the large Hispanic community we have. And if you know much about these folks, you know that this is the way they operate within the Mexican criminal justice system. It's a very underhanded system in a lot of ways. It's hard to tell if there's a lot of honesty involved in it. And judges and other court actors like lawyers, for example, who endeavor to represent defendants and to represent the country of Mexico, and as well as the people, the judges, are constantly murdered. And it causes people to be afraid to come in and serve on juries and be a part of that system. So the whole idea behind this bill was to really address that fact, to send a message throughout the community that you should not attack the criminal justice system in our state by attacking one of these peoples. And it's not limited to just judges. And finally, I would say this, that the reality is anybody who does anything that we can imagine in the courtroom, from the criminal defendant that you may see on YouTube who turns the table over and attacks his defense attorney, to someone who may attack a prosecutor or who may attack a judge, they're going to receive a sentence which far exceeds the minimum that the statute as proposed would have in it. So there is, from our perspective, utility, though, in sending the message in the community that you shouldn't do this type of thing. And so that's where the idea came from.
Thank you, Mr. Franklin.
Thank you. What you'd mentioned that as this bill doesn't address jurors, what is the penalty range for the assault on the juror?
I don't know, Representative Franklin. My understanding is they have a special code section that deals with that, and it should be equivalent. If it's not, it should be. And I don't have the answer to that. And
is there anything that would provide any enhanced penalty for someone who is ordered by the court to be there by a subpoena, to be there? They've got no choice. They're not there as a spectator. They've been ordered to be there by subpoena. And I'm just wondering if there's any enhanced penalty for that individual.
Well, this bill would provide that in a limited capacity in Section 4, I believe, because it talks about people that provide documents. So if they're there producing documents in relationship to a subpoena, if you look on Section 4 and then you look back up in Section 3, if they're there providing the court with testimony and this documentary, then yeah, they would have some protection for terrorist threats. But I'll say this, we have no objection to adding those types of folks to the same type of enhanced penalties because it's consistent with the philosophy about why we think a statute should be passed to start with.
Judge, thank you.
All right, thank you.
Forgive me, is it Griesbach or Greisbach? Griesbach, thank you. I apologize. Did you have to comment on? Okay. Okay, thank you very much. I see no one else has signed up on House Bill 1002. With that, what is the pleasure of the committee? Move to pass by Mr. Levitas, second by Mr. Ramsey. Are there any amendments? Ms. Abrams.
Yes, I'd like to move that we amend line 57 by striking the word or, and line 58 by striking the words less than and replacing it with to exceed, so that the line would read by a fine of, nope, sorry, I misread what I did. Okay, sorry. Strike on line 57, strike the word of. And so it would read by a fine not to exceed $100,000 or both.
The proposed amendment by Ms. Abrams, line 57, for not less than 1 nor more than 10 years or by a fine not to exceed less than $100,000.
No, not to exceed 100,000. So you strike less than.
Oh, I'm sorry, not to exceed 100,000. Or both. Is there objection to the amendment? Hearing none, the amendment is adopted. Any further amendments? Mr. Franklin.
I just have a discussion.
Okay. Seeing no further amendments, any further discussion, Mr. Franklin?
Thank you. I thank Chairman Ramsey for anticipating my comment, but I am concerned that while even though the discussion on the bill is about providing protection, the bill really doesn't protect anyone. It provides enhanced penalties for those who have been victims of assaults. And just thinking particularly of the case recently that was in the news in Cobb County at Penske, I am concerned that while the minimum 1 year sentence for assaults there versus here a minimum of 5 would I'm not certain that sends the right message to the people. And the sports analogy of the referee, and now in this case the judge, is the protector of the institution. I would say the people are the protectors, and the judges are the employees of the people in that particular setting, and it's the people that we need to be ensuring receive all the justice that the law can afford. And I think by saying that certain government employees there's a higher penalty, I'm not certain that's the right message to send. Thank you.
Thank you. Any further discussion? Seeing none, on the gentleman's motion of do pass by substitute for House Bill 1002, that's LC 294154S, as amended. All those in favor of the motion, please signify by raising your hand. Opposed? And the motion is adopted. We'll turn next to House Bill 884. Representative Levitas.
Thank you, Mr. Chairman. I bring before the members of the committee House Bill 884, which amends the aggravated child molestation law to include as an aggravating factor when the act is committed with force. To give you, in anticipating some of the questions that may come, one of which I know the chairman has posed to me before is why isn't force defined? The reason I have not defined force in this is the same reason that it's not defined in the rape statute, and the rape statute involves carnal knowledge of a woman forcibly and against her will, and the term forcibly is not defined there. It's been established by case law. And these scenarios are often so fact-specific that it needs to be determined by a trier of fact as to what constitutes force appropriate in this case of aggravated child molestation. And what I've handed out to members of the committee are some case law that would shed some light on how the courts have treated the term forcibly in the past. And I won't go through that. It's in front of the members. But what I will point out is to give you some example in a case that actually happened in Driggers versus the state. And this was a case that involved aggravated sodomy. And in that case, the victim was aware that the offender had guns all around the house, and the offender repeatedly threatened to shoot and kill the victim if the victim did not engage in the sex acts. So in some cases you would have true physical force where somebody physically restrains or hits them, does something like that. And in other cases it would be sufficient to be unable to get yourself out of that situation because someone is exerting level of coercion that rises to the level of force, and this would be, Driggers versus State would be one such example. And with that, Mr. Chairman, I'll take any questions that committee members have.
I think it'd be helpful if, I mean, to the extent that you can and are comfortable, what I'm trying to think of are the scenarios whereby the current law is not sufficient.
Well,
I think that might actually help, connect the dots for the members.
Sure, and the current law just doesn't treat aggravated child molestation. It does not treat an element of force as aggravated child molestation. So if you committed the act with force, but it didn't involve sodomy and didn't result in a physical injury to the child, it would be regular child molestation. And I certainly believe that any act that involves force should rise to the level of aggravation in the same way that it does in aggravated sodomy, in the same way that it does in rape cases. If it is one element, it's not excusable, but it's one thing if the child is engaging in conduct where they're not forced to. They can't consent to it, of course, but they're engaging in it for whatever reason. They are, although they can't consent, they're willing participants in it. They've been talked into it. But it rises to another level where you're talking about of forcing them, either through physical acts of restraining them, hitting them, choking them, or in a case like Driggers versus the State, a 2009 decision, where the coercion is so strong that they feel unable to resist something that they don't wish to participate in. And that's what separates it from a regular child molestation case. They, of course, can't consent in any case, but here you're adding the additional level of force. And already in law, even if it was something that the child wanted to engage in, by this simple act of sodomy, we've already said that if it involves that, it rises to the level of aggravation. And certainly if an act of sodomy, whether it's you have a willing participant or not, and I'm not talking legally, but if you in fact have a willing participant, if that rises to the level of aggravated sodomy, certainly when you're talking about acts of force as occur with aggravated child molestation, aggravated sodomy or rape, that ought to rise to the level of aggravation for purposes of treating it as aggravated child molestation.
Questions for the author? Seeing none. Ms. Michaels with the Georgia Association of Criminal Defense Lawyers. Ms. Sandra Michaels, excuse me.
Representative Levitt allowed me to speak to him before the committee about the bill.
Let me ask you to pull the microphone.
Yes, sir.
Thank you.
I just have a couple concerns about the bill. One is anytime you add a new element to a crime, you open up the door for a lot more litigation because the litigation will involve what is committed with force mean. And I'm sure as most folks here know, that under the 1661 rape section, which is precedes this in the code, it's a female forcibly and against her will. I believe the use of the word force in the rape section is not the same use of the word force as I think is in line 13 in subsection 3. It's a different type of force in the sense of it's connected with consent. And a child, of course, in child molestation cannot consent because they're a child. The issue of force in rape is a different concept. It's not the same as use of force. The other concern I have is that in the last several years, the Georgia legislature changes the sex offenses fairly regularly, and the case law has not really been able to keep up with the changes, and it just seems like we should let the legislation that we have on the books exist and settle down and see what plays out. As you know, we changed the kidnapping statute last year in response to a case, and I can understand when we're going to change the law in response to a case. I may not agree with it, but here there's no problem that we can think of this not being solved. How many cases is this going to affect? Is there some kind of issue that's not being resolved by changing yet another aspect of our sex code? And that's my just concern with us changing that. Also, if you look in the penalty section under 1664, which you don't see in this bill, if you're going to have is committed with force, you don't have a definition of force, but if the intent of the author is force should be similar to the force as defined by the case law on rape, I'm concerned that you're going to catch in a lot of things that you didn't intend to, and the penalty is life nor less than 25 years in a split sentence, and that's a very severe penalty for something that's not clearly defined, and those are my concerns.
Is force defined in the rape context in the code?
No, but if you look at
it's all evolved through case law, is that correct?
Right, it's all through case law, but it's usually in the context of did they agree to it or not? Was it force? It's not defined as like holding somebody's neck and holding them down. It's the force is usually the issue of whether it was did they consent to it, not by bodily harm, which I think is.
But case law has evolved into defining what force is, including non-physical force, coercion, etc. Is that a correct statement?
Correct, and the same.
So wouldn't it apply? Wouldn't the courts apply the same definitions?
No.
Of force in those contexts that they would, or would they?
I don't think that's what I'm saying. I don't think they would, because to me, in my mind, again, I'm not the judge, but the force issue in rape is related to the consent issue, not force related to there's guns in this room if you don't do what I say, I'm going to do it. I'm just saying it creates a law that's certain right now and creates some uncertainty, which is we've been dealing with a lot of uncertainty in our sex offense laws in the last several years, and I think this opens the door to more uncertainty.
Mr. Ramsey.
I guess I heard you say something. I just want to make sure I understand. You're suggesting that we shouldn't act to address a perceived gap in the criminal code to allow case law around previous efforts to address gaps in the criminal code as perceived by the legislatures to allow the case law to catch up?
I don't think that's what I suggested.
Well, you said we need to allow case law to settle out on previous enactments addressing areas of the criminal code, particularly around sex crimes. So you're suggesting we shouldn't move on this to address what I think is a very valid issue created by this court ruling to allow these other enactments, the case law around those previous enactments, to catch up. I think that'd be a pretty bad reason for us not to move on this bill.
I think what I was trying to say, and apparently not very articulately, was that we have changed our sex offender laws so much in the last several years, both penalty, definitions, the sex offender registry, that every time we change something, and this is actually adding another element, that it does, when you change the law, it creates certain uncertainties, and I'm not sure that this is such a large problem that we need to change the law on it. And I don't know how many cases are falling through. I don't think the cases cited on this piece of paper necessarily mean that the perpetrator was not charged properly. It's just an issue of what is force, and do you want to change that?
It's not adding another element to the crime. It's just adding another way you can commit aggravated child molestation.
Is committed with force would be an element that would have to be proven. Yes.
No, it's if you're charging under that
yes.
Under that theory, right?
Yes.
Okay, but we're not. Okay, I think we just when you say element, it sounded like you were saying we're changing the elements of an aggravated child molestation. I'm just suggesting this is we're adding an additional way that aggravated child molestation can be charged.
Yeah, right. It's another element to that would create uncertainty, and the concern is with that and such a large penalty under this section, when you have such a large penalty in certain cases, they're designed to handle the worst of the worst cases, and all I'm saying is that we're changing something I'm not sure needs to be changed.
I appreciate your clarification. At the appropriate time, I'd like to be recognized for a motion, Mr. Chairman.
Thank you. Ms. Abrams.
And this is actually for the author. The notion of mental coercion when it applies to children, I think, is a different standard than when it applies to adults. Is there any case law, either in Georgia or elsewhere, that addresses the fact that fear induced in a child is very different than how you induce fear in an adult. And under the language of the case law that you've presented, mental coercion of a child, my concern is that we are lowering the standards so low that the term force does encompass a much broader notion than it would in an adult. And if you thought about that and what that means, that, which is not to excuse the notion of child molestation at all, but did you look at what would happen with a child, what a child would consider something that induces fear versus what happens with an adult to induce fear?
And the short answer specifically is no. But what is clear about child molestation, which is different from rape, is that the legislature has expressed an intent that we're going to lower the bar because we're not even going to consider the consent of a child because we believe that the child cannot consent. And similarly, the actor takes the victim as he or she finds them. So if the standard for coercion is less in a child, my suggestion would be that would be appropriate. In other words, the coercion should be perceived as the victim. And if you engage in child molestation with the victim and the coercion level that a court may or may not accept may be lower, I think, again, that's appropriate.
Thank you.
Just a question for the author. What issues do we potentially run into with regard to, and I guess this is really a function of how the case law has evolved, but can you clarify for us, we get into, is it force, is it not force? So we're just stipulating that we're relying on, this really goes back to my question from Ms. Michaels, where do you see force as it relates to this particular issue evolving in terms of case law? Because we're not going to go ahead and define it. It's not defined anywhere, right?
Right, that I'm aware of.
Okay. So are you relying on interpretation of force as it's been interpreted in other areas as it relates to rape, or, that's what we're just intuitively presuming?
That and aggravated sodomy, similar case law. And I do want to clarify one point that I guess is a point of disagreement between Ms. Michaels and me. When the law talks about rape, it's not talking about consent only. It's very specific that it's both forcible and against the will. So it has to meet both of those elements, which are separate elements, and the case law is replete with having to prove both of those elements. So I would suggest that the force is very distinct from what the issue of consent. It may play a role in it, but it's actually a very separate and well settled through litigation element of the offense. And I do want to point out just one other difference, that when Ms. Michaels referred to the kidnapping statute we had here, the difference there was 40 years of well settled case law, and overnight the courts not only said no, but here's your new test. So they actually were changing an element of the offense and changing existing law on the books. I would tell you judicial activism. Boy, that was not easy to say. And that's different here. What we're doing is we're adding an additional element for the way that you can prove it. It's an alternative method. But again, we're talking about force being committed, and the case law is replete with examples of what might rise to the level of force. I don't think that any bill could define in each and every case what is appropriate force. And I do think there's a very well settled body of case law out there that would speak to this and very rapidly develop what is or isn't case law, or what is or isn't force.
Do we do better to take that body of case law and to develop a definition ourselves, or not?
I just think that's virtually impossible because these vary so much by the fact scenario. And I guess it speaks to what Representative Abrams' question. You have to look at the mind of that particular victim and see whether it's reasonable. For example, in that Driggers case that I mentioned, part of the court's reasoning was that the victim was actually aware of the guns being around the house. It wasn't the fact that guns were around the house. It was her awareness of it. And so in this case, I think you would have to have what the fact-specific situation was for the child in that circumstance.
I'd like to hear what the prosecution community thinks about the bill. Gwendolyn Keyes Fleming is the district attorney for the DeKalb Circuit.
Thank you, Mr. Chairman, for allowing me to speak. I've had the opportunity to speak with Representative Levitas briefly about this. I wanted to make sure I got a good understanding of what he was trying to achieve, and I just had the benefit of that not too long ago, so I have not had the opportunity to go back and tell the DAs about it and figure out where we stand as an association. I think one of the things that I am concerned about as I read the statute, and I brought this to Representative Levitas's attention, as you read the subsequent parts of the code section, the Romeo and Juliet provisions, it talks about that if there's someone that's 18 victimizes someone that's 14, then it is considered a misdemeanor. And my concern is we as a prosecutor would not want someone who forcibly causes someone to do the acts of child molestation to be treated as a misdemeanor. So I'd want to make sure that whatever, if the committee decides that this is the way in which they want to go, that we don't set prosecutors back by limiting us from prosecuting people who force things to do these ungodly acts as felons as opposed to misdemeanors. I hope I'm making myself clear.
I mean, would that entail a carve-out on the Romeo and Juliet?
I think you would have to say, except in the case of force, it would be a misdemeanor, something along those lines. Otherwise, we would be stuck. And even in a lot of times, these types of fact patterns fall under several code sections, and we just don't want to be prevented from prosecuting this level of crime as a felony if there's something in the code section that says force between this age group should be considered a misdemeanor.
Ms. Abrams.
And actually, if you can respond to this scenario, I support the underlying premise of the bill. My concern is the expansive nature of what constitutes child molestation. So can you tell me if this is true? A mom tells a child she's got to stay in the room. The mom ends up having sex. The child watches the mother having sex. Under our child molestation rule or law, a person commits the offense of child molestation when she does any immoral or indecent act in the presence or in the presence of or with any child under the age of 16. So you're a prostitute. You have sex in your room. You make your child stay in there because you don't want them wandering off. They know they've got to stay there because they're afraid of mommy. Social services comes and takes the child. The child reports this happened. They've committed an act of child molestation, and on top of that, they've now committed aggravated child molestation and would be subject to a minimum penalty of 25 years because the child felt that they were afraid to leave because mommy said stay.
I think even in that fact pattern, we would need some sort of threat by mom to demonstrate that. At least I would require, as a prosecutor, before I would even charge that, some type of affirmative act by mom that she either threatened the child right before engaging in the prostitution act in that child's presence. Something more definitive than, that's my mom and I'm afraid of her.
Don't leave or I'm going to spank you. I need you to stay in the room or I'm going to spank you. It would then be subject to...
And again, I haven't had the opportunity to go back and review all of the cases relating to force, but I would assume force needs some type of imminent danger and harm as opposed to, and that's not to say that spanking can't be imminent and dangerous, but I think in the terms of force, they are talking about some type of weapon threatening bodily harm. But I'd have to go back and research it to be sure.
And if I may, to the author, just looking at the document that you gave us under the citation from Brewster, it says our courts have held that the term force includes not only physical force, but also mental coercion such as intimidation. Lack of resistance induced by fear is force. If that's the language, I guess going to Chairman Golick's concern, my concern is that this is a fairly expansive definition of force that doesn't require proof of intimidation, doesn't require concern for bodily harm. It is simply the issue of some mental coercion. And to your point, you meet the child where you find them. My concern is that this creates a minimum standard of 25 years for an act that may or may not be as egregious as we would intend it to be to qualify for aggravated child molestation. We created two separate statutes for child molestation versus aggravated for a reason, and my concern is that absent something that's more definitive than the ephemeral sort of case law, what someone may read to be the case law of what constitutes force, you run the risk of being overly expansive in its application.
Mr. Levitas.
The response would be that again, even within those statutes, when they're talking about intimidation, it's not, I'm going to be mad at you. or you're not going to be able to watch television. In the case where we had, again, going back to Driggers, that was a intimidation, a coercion, and in the first one that I mentioned that's cited approvingly in Brewer, it defines the term forcibly means an act of physical force, threats of death or physical bodily harm, or mental coercion such as intimidation. And, again, to some extent there's, of course, prosecutorial discretion, but even if that isn't exercised in the case, I think the well-settled body of case law is not going to find that, I'm telling you as your mother you have to stay in the room rises to the level of mental coercion or intimidation. I mean, those are mental coercion to me is a very weighted term. It's not, I better do it or I'm going to get in trouble. I mean, coercion is something where you're unable to resist because of the nature of the threat, such as I've got guns around my house.
But which goes back to my earlier question, which is that when you're talking about a child who's 5 or 6, the threat of a spanking can seem almost as egregious. And my question to you earlier was, does that constitute the same? Would that meet the same level of intimidation? If you're an adult, your ability to discern what constitutes actual threat of bodily harm is very different than your concept as a child. But what this requires is that, your answer to my earlier question was that it's the child's mental state that would be taken into consideration, and therefore, if their mental state does not give them that higher cognitive capacity to recognize the spanking is not the same as being pistol whipped, then they're going to sorry, we're reading a strange book right now. That absent that, you face the same level of potential. You would fall squarely within the case law of what constitutes mental coercion, which differs if you're 3 versus 5 versus 10 versus 15.
And my response to that is that you cannot read each element individually. You have to read them in the context that they're defined. And when you have the description of physical bodily harm there, I don't think you can just pull out intimidation and say, well, that's just being intimidated. It's obviously in this string of descriptions of what constitutes forcible, you're talking about physical force, threats of death, or physical bodily harm, or mental coercion. And that's what they're talking about at a very high level. They're not just talking about, in my judgment, even for a 5-year-old, do you think a spanking is like, being shot or being hit? That's what appears in the case law, that it has to rise above the level of ordinary intimidation to the level of coercion. But I will also again say that you find your victim the way that they are. If you choose to engage in those acts that are going to be different, how an adult might perceive them as a child, that is the nature of the offense, and that's why we hold folks to a higher standard for acts of child molestation than we do for ordinary acts.
Thank you.
I don't see anyone else signed up for it. I think what I'd like to do is, Representative Levitas, is in light of, at the very least, in light of the prosecutor's concerns on the Romeo and Juliet scenario, I think I'd like to hold it, maybe give you and them the opportunity to flesh that out a little bit more so we can have more of a collective comfort level before we get to the possibility of a motion.
And that's fine, Mr. Chairman. Of course, if we're going to go forward into new territory, we need to do that, as carefully as we can. And I would just ask that the district attorneys come back to me with both any concerns they have and any proposed language that would constitute a carve-out. Because I agree, certainly I would not want to put my bill in a position of both rising aggravated child molestation based on force and then dial it back down without making sure that we dotted all our I's and crossed all our T's.
And we can talk about it offline, but if we are going to rely, perhaps to our detriment, on court-driven definitions, then we're talking about what is force, we're talking about what is coercion, how have the courts defined that, and I think we do well collectively as a committee to understand exactly what those definitions are right now in the current state of case law here in Georgia, because that's ultimately what is probably going to end up being the roadmap for the courts. It would obviously be new in the context of aggravated child molestation, but they have to start somewhere, and they're probably going to start with the definitions that they've used, or not the definitions, but the tests that they've used in other issues impacting other similar statutes, although not this statute.
And the only thing
I don't know where else they would start.
Right, and I agree with you wholeheartedly. The only thing I would ask, and I direct this not specifically to Ms. Keyes, but to Prosecuting Attorneys Council in general is for them to understand that we're on day 19 and that crossover day is 33, so that this is not something 30. I'm sorry, day 30. You're correct. So this is something that I would need back from them at the earliest possible time.
All right, Mr. Lunsford, do you have something?
Mr. Chairman, if I could we get Judge Ray's opinion, since Gwinnett County was nice enough to let him come down here and visit with us today? Judge Ray, would you have an opinion on this? Because I'm sure you've actually heard similar cases to this in your courtroom, unfortunately.
I can give a stab at it from my perspective. I certainly can't speak on behalf of Superior Court counsel. Normally, we don't take unless a bill affects the processes of the operation of the courts, we leave that out, to the legislature and don't offer input. I understand the intent of the bill, and without commenting on whether that's a good or bad thing, I have a personal opinion, probably similar to Representative Levitas. Case law is difficult to work with at times as a trial judge, trying to figure out what things mean and what. It's a lot easier for me as a trial judge if it's something that's statutorily defined in general than trying to look at the case law. I mean, that applies to anything.
We prefer that too. Shocking though that may seem.
Yeah. And the activist judges were on a couple of levels up from the trial judge. I want to point that out. So, to the extent that it can be defined, it makes it easier for us when we're working with jury instructions. And I understand that sometimes it's hard to adequately define something that works in all situations. I mean, we run into that all the time in bills that have passed that might not just fit. Ultimately, I think in a lot of those cases, though, and this is going to be the exact opposite of what you wanted, because I'm not going to bring clarity at all. I'm going to circle back around the other way.
Judge Ray, actually, you're highly respected on the bench. We appreciate your opinion.
I think most judges really look to the district attorneys to exercise discretion in those appropriate cases. I mean, you can make a statute, you can pass any statute, and in any particular case, it seems absurd when applied. And by and large, we've got great prosecutors, and they weed a lot of that stuff out before it ever makes it to trial. Now, there are certainly some cases where that doesn't happen, but in most cases, I think prosecutors utilize their discretion very appropriately.
Thank you for your perspective. With that brings this meeting to a close. We are going to have a meeting tomorrow morning at 9:30. Remember, we don't go in tomorrow until 2 p.m., so we are going to have a meeting tomorrow at 9:30. We're going to send out the agenda immediately, so please make every effort to be there. We're at that point where we don't necessarily have a backlog, but we are going to be meeting a little more regularly just to make sure that we keep the wheels on the track and keep the flow of legislation going to give members every opportunity at rules to get their measures out on the floor. So with that, we're adjourned. Thank you.